loved one right before they need care. And it can be kind of panic mode for a lot of people because it's a lot at once. There's a lot of things you need to be aware of, and it's unfamiliar territory for a lot of people as well. So what I'm going to do today is walk through some of the things that you maybe have heard, some sort of myths, things like that people say, oh, this is what you should do in this situation, and what you should actually do instead of those things. Because a lot of the things you hear online, as is generally the case for a lot of things, are unfortunately not either accurate or not good information at all, or potentially just downright damaging to that person's situation. So you really want to be very careful what you read online and get the right information. So welcome, everybody. I'm attorney Justin Randall with Hooper Law Office. Thank you for joining us today. Our topic, as I mentioned a moment ago, is what to do if your loved one needs care soon. And care meaning, like long-term care, like skilled nursing facilities, assisted living facilities, or potentially at-home care as well. But not necessarily just like, oh, I'm going to the emergency room type care. That's a different situation. But if you are participating via Zoom, you should be able to ask questions through the Q&A function. So if anything comes up that you want to ask questions on related to the topic today, I can answer them as I see them come up. Or if you're uncomfortable doing that, you're always able to email us at learnmore@hooperlawoffice.com too, and somebody will get to that question and help answer it for you. You'll be getting a couple materials from us today if you did sign up in advance. One of them is the kind of things that you need to be careful of when a loved one needs care soon, and sort of here's what you may be doing and here's what you should be doing, instead of doing those sort of potentially damaging things that a lot of people do when they're trying to plan for a loved one who needs care. And another is, warning signs for a loved one's estate plan. It kind of covers some things like, oh, they say they're going to get to their estate plan at some point, but haven't really gotten around to it. Things that, are some red flags that you want to be aware of, especially with parents or close family members. So when we're talking about things that you need to be aware of when a loved one needs care soon, obviously this can be a very stressful time for anybody who has not experienced it in the past, or even if you have dealt with it in the past. There's a lot of unfamiliar territory where you may not be familiar with how certain programs work or what the process is like when someone needs care. Or the most dangerous thing is people tend to Google for the answer, right? And the information out there is either sometimes incorrect, potentially just risky to that person's, potential, the like qualification for certain care, programs, things like that. But also it can be just sort of misleading in a lot of ways. So the best thing you can do if your loved one needs care soon, or you have that concern, is you start talking to people who work in this area, right? You want to make sure that if it's a parent or a loved one, that you ask them about, okay, what kind of estate planning documents do you have? Do you have a power of attorney for finance? Do you have a power of attorney for healthcare? Do you have those sorts of documents in place that will allow somebody to step in and help manage things for you if you can't yourself anymore? And if you are that person that you've been told is the power of attorney agent, do you have copies of those documents? Do you know where they are if you don't? Having access to those is really important. But one of the biggest mistakes that people make when a loved one needs care soon is thinking that all powers of attorney are created equal. A power of attorney, especially for financial decision making, is really only as good as the authorities that are listed in it. So if you don't have the right authorities in a financial power of attorney that somebody is going to need in order to potentially do legal planning for somebody, long-term care planning for somebody, or help them protect some of their assets from care, without the right authorities in those documents, it can be very, very unfortunate when somebody loses capacity themselves and can't sign new legal documents, because then unfortunately you're stuck with what you may have. The biggest concern I would see is if somebody came in, for example, with just like the Wisconsin state statutory form, where it's very vague what sort of authorities are included in it. Um, you want them to be very specifically listed, things like, but this is not an exhaustive list by any means, but things like, setting up trusts, potentially, gifting, the ability to, talk with certain individuals, like, can they do legal planning for you? Can they go to the bank for you, pay bills? I mean, all of those sort of things you want very specifically to be listed in there. There's no real one authority that will say something like, oh, my power of attorney for finance can do long-term care planning for me, but it will be a collection of authorities that really allows the agent then to step in and do what they need to. And you just want to be aware of what you have, right? Or if you're the one who is the power of attorney agent for somebody, be aware of what you are and are not able to do through that document. So one of the first steps you're going to want to do is talk to somebody who practices elder law, or ideally elder law and estate planning together, so that you can get the right information that you need. So powers of attorney, always a first step for things like that, if possible. But there are a lot of things people do when a loved one needs care that they accidentally create more issues than problems they actually solve. So one of the big things is when a loved one is paying a family member for care. Maybe that family member is actually coming into the home and actually providing that care. Maybe they're a nurse, maybe they are just a family member that is helping them out. But paying a family member for care when you may need to actually go into a facility sometime soon is actually very dangerous without the right documents in place. When we're talking about someone needing care soon, a common concern is how to pay for it, right? Because it's very expensive. So when somebody is unable to pay for long-term care out of pocket anymore, once they qualify in terms of the amount of assets they're allowed to keep for Medicaid, Medicaid is the program that then steps in and helps pay for that care. But there are a lot of things that people can do to cause problems for Medicaid qualification, even after they've met that asset limitation amount. And one of the worst things that happens is when a loved one has been paid to give care to the parent or of the family member, and they don't have what's called a caregiver agreement in place. In terms of Medicaid qualification, the reason this can cause an issue is when you just give money away to somebody, or you pay a family member and you don't have, you have to report your financial statements to Medicaid and say any sort of gifts that have occurred over the last 5 years when you're applying for Medicaid. And even though you're paying someone for an actual service here, if you can't explain that was for care and you don't have what's called a caregiver agreement in place with that family member, Medicaid is going to assume that it was a gift, even though it really wasn't. So paying a family member without what's known as a caregiver agreement in place is a huge red flag and can create a lot of problems for somebody in terms of qualifying for Medicaid when they actually need it. So a caregiver agreement is essentially a contract that somebody signs with a loved one, agreeing on what the going rate is for that care. It has to be a notarized contract, so it has to be shown that it is a valid contract. It's not somebody just signing a piece of paper saying, "Yep, this is my caregiver agreement," right? So there are requirements to actually set it up the right way. And this kind of ties into a good financial power of attorney, because a good financial power of attorney is going to specifically allow for that agent to set up or put in place a caregiver agreement for the loved one, so that they can provide care and receive payment for it, for the service they're providing. And then that caregiver agreement is that rebuttal against Medicaid's presumption that was a gift or that you were trying to hide that money. It makes it so that does not create an issue for those payments when somebody does need care. So paying a loved one for care without the proper documents in place is a huge issue for somebody who is about to go into care. So say though you're past the point where you're not able to pay a loved one for care anymore, or it's just not the level of care that you or that person is going to need anymore. What do you do when you're looking for a place to to stay? How do you find the right facility? How do you know where to even begin looking? And it's a lot of information that somebody would need to go through when they're looking for places of, what's the closest facility to me? Do they have the right care for the person I'm looking to help? Do they have how expensive is it going to be? Do they have any requirements for how long someone has to privately pay the facility before they will let them live there on Medicaid? These are all various factors that someone needs to be aware of when they're trying to find the right place for a loved one to receive long-term care. But thankfully, you don't have to do that on your own. It's a lot of information to try to go through, especially if this is not something you do for a living, or it's a new area or just a completely new issue for you that you're dealing with. There are a lot of organizations out there that their job is to help people find the right place for a loved one to receive care. And, they work with the families on finding places that meet their financial ability to pay, and how long they're able to privately pay, and what type of care that loved one is going to need, and helping them find the right place. And many of these organizations do not even end up charging the families for that service. They get paid by the facilities that they recommend people go to. So it's a lot of these organizations are very, very helpful to clients, and helping you figure out, where do I even begin? And they really are sort of lifting that weight off of that person's shoulders, trying to find the right place. So the question becomes, though, is, okay, once we get to that place, once we know where we're going, what can we do to protect assets? What can we do to not have to spend down all the way to the Medicaid qualification limits? Which, if you're a single person, it's pretty straightforward. The most you're allowed to have in assets is $2,000 in countable assets. They can keep the single person can technically keep the home, but Medicaid will place a lien on that home. And they can keep a vehicle. It doesn't matter the value on the vehicle, and a life insurance policy of not more than $1,500 in face value, and that's total. So you could have multiple life insurance policies. They just can't be more than $1,500 in face value. If they go over that face value, then they look at the cash value as an asset. So anything over that exemption amount, would disqualify someone from being Medicaid eligible. So a lot of people try to find ways in advance then to protect assets. They try to move assets out of their name so that they're protecting those from being eaten up by their care costs. And so this often involves gifting, which I alluded to earlier. But the problem is that it's the way people gift, or how they're setting up these strategies, that create the issues for them, not necessarily the act of the gift itself. Many of you have probably heard about that 5 years for Medicaid. What that 5 years is that's Medicaid saying, when you apply for Medicaid, we can look back the previous 5 years to see if the person who is the potential beneficiary of Medicaid benefits, have they given anything away for less than fair market value, or like gifted it to anybody, just to a family member? Have they done anything to get it out of their name to help them get Medicaid eligible, essentially? And if you have, they give that, or if that person has, they give them a penalty based off of the value of what Medicaid calls divested. So that's giving it away for less than fair market value. So if, to give you just an easy number, Medicaid has a divisor they use that is how they calculate that penalty. So roughly a $92,000, if I had given away $92,000 in the 5 years before I needed care, and then I applied for Medicaid, I would have about a 10-month penalty period. So Medicaid's penalty period is not a financial pay us back. It's, we just won't, as Medicaid, won't provide any benefits for your care until you have made it through that penalty period. So the 5 years that Medicaid is referring to, and that people often talk about, they're trying to get past that 5 years, is because once you get beyond 5 years from making a gift like that or a divestment, you don't have to report it to Medicaid. So people often try to do this planning in advance to protect assets. And I'm going to use like somebody's residence, their primary home, as an example here, because it's the most common thing that people are trying to protect. And it's something that most people can kind of conceptualize and relate to. And one of the biggest things I get asked is, should I put the home in my kid's name? Somebody, parent trying to protect their house from long-term care expenses. And the reason that is so dangerous is not just the fact that you are creating a divestment for Medicaid, because a lot of good planning, prospective planning, you're sort of you making an informed decision to saying, I am going to make it out that 5 years, so I can make this divestment now. It's not that part of it that's the problem. It's what happens after that divestment is made where the concern really comes in. So if somebody has made that divestment, well, what happens to the home after that? If they're not if their name isn't on the deed anymore, they're not the owners, they put it in the kid's name. Well, the kids are the owners, and the kids can dictate what happens with that home. This is where you hear the horror stories of people, evicting their own parents or charging them rent, things like that are really concerning in terms of long-term care planning. I mean, one of the biggest components of long-term care planning is about maintaining as much control as possible, and losing that control to that extent, because when the biggest loss of control somebody can have is by literally giving something away and not owning it anymore. So hopefully, somebody's kids wouldn't do that, but it just goes to show you that it is a big loss of control. The other concern with that is anything that happens to owners of a property also happened to that property. So when you own your own home, if you were sued or you filed for bankruptcy, and you have some protection over your own primary residence of what can happen to that property, who can take it, right? What types of liens they can put against the property. But when it's a secondary property, which it would most likely be for a lot of people's kids, right? They may not live in the residence as their primary residence. You don't have that same protection. You don't have the same liability protection or divorce protection or creditor protection, bankruptcy protection against that home. So if any of the kids end up having any of those issues, they have creditor concerns, they file for bankruptcy, they get a divorce, they get sued for whatever reason, anything like that, well, that potentially now happens to the home that you live in. And so you want to be very careful, even with the most trustworthy kids in the world, of just putting something in their name without proper planning in place, because that can really create a lot of issues. One of the biggest concerns as well is, well, what happens if any of those owners pass away, right? The new owners, the kids. Well, their share of that property is going to go by the terms of their own estate plan. So, are you prepared to start owning or living in a home owned by your in-laws or by your grandkids or whatever the situation is? These are things people don't often think through when they do this type of planning. It's just more of I want to protect it from my care. I'm not going to focus on what the potential future consequences are of it. Another concern as well is when people do this, they often continue to pay the property taxes themselves and utility bills and all of these sorts of things. And they don't have a rental agreement in place or anything of that nature. So the question becomes then to Medicaid, okay, so say you made it out 5 years from the actual gift of the home. Well, why were you paying somebody else's property taxes for 5 years? And you're not going to be able to explain that away. So that payment of property taxes on a home you don't own is another divestment. And so you're just making these continual divestments every time you make that payment. So you might get out from one divestment and just create more along the way with just putting it in the kid's name. And this is a very common issue that comes up for people, is that continued payment of property taxes. It's also bad tax planning to gift a property like this during your lifetime. When you pass away, owning that home and it's part of your estate, when you pass away, you get a tax adjustment, a tax basis adjustment up to the fair market value at the date of death, so that when your kids turn around and sell it after they've inherited it, there's no, or very little anyway, capital gains taxes that they need to pay on that sale. When you gift a property over during your lifetime, that your cost basis in that property transfers to the new owner. Think of cost basis as essentially, what did you buy the property for, right? That's a pretty basic explanation of it, but it's, more often than not, what that cost basis ends up being close to is what did you buy the property for? So if you bought your home or built your home in 1950 for $50,000 and it's worth $250,000 today, well, that's a $200,000 gain of value. When you, as the primary resident and owner of the home, sell your own property, you have an exclusion from capital gains up to $250,000 a person. Your kids, as non-residents of the home, don't have that. So you want to be very careful, if you're concerned about those taxes at all, that you're doing the strategy the right way, or you're protecting the assets the right way. So one of the ways that we would do this instead is using something called an irrevocable trust, where the kids are not the owners of it. It's still a divestment initially, so you're still concerned about those 5 years. But it has a way for you to have some limitations on what the trustees are allowed to do. They can't evict you, they can't charge you rent, they can't sell the property, as long as you are upholding your end of the bargain of that trust as well, which includes paying property taxes. So it gets around a lot of these issues. But what happens if you didn't even do the 5-year gifting, strategy? You're not, you didn't think ahead about it at all, and you're just trying to get things out of your name now. Well, you need to be very careful about the levels of gifting that you've been, engaging in right before someone needs care. I mean, this is not something that you want to do without consulting an elder law attorney, or an estate planning attorney on before you need care. You don't just want to move it all at once, because that is going to cause a divestment. And the issue is, how do you get that money back? Is there a way? Are the people you're gifting it to, are they spending it right away? What's going on with that? And if you cause yourself a penalty for Medicaid and you don't have the money to pay through that penalty, you get stuck in a really bad position, and it can be very difficult to get through that. So you want to make sure that if you are engaging in gifting, that you are doing it on the advice of an elder law attorney, that you are using proper strategy, and you're not just doing it without thinking. This includes a lot of things that happen even when people aren't thinking about prospective long-term care. They're just, I loaned my kid $20,000 for something, and they may pay me back, but they may not. Well, that's not just a loan, then that ends up being a gift, because without that anticipation of getting paid back, or that kind of laissez-faire attitude about getting paid back, it's going to be considered a gift for Medicaid. So you really want to be careful about gifting strategies in advance, and making sure that you are doing it with the advice of an elder law attorney, or they are helping you strategize how to do that and set up the proper protection. Without doing that sort of initial consultation with an elder law attorney, or having them sort of design that protection plan for you or your loved one. Don't listen to the internet on anything related to gifting. Don't listen to, as long as you make it out the 5 years, you're fine, because there's a lot of things that, the general public is not going to be thinking about, because they're just not familiar with the intricacies of Medicaid rules for eligibility. There are a lot of things as well that you want to be aware of in terms of married couples needing care soon, or one of the spouses needing care soon. It's not just, they don't just take half of everything. That's a common misconception I hear, or, somebody says that somebody at the facility told me this, or, I read it online, whatever it might be. You want to make sure that you are not using exempt assets on one spouse's care either. And so what I mean by this is, when one spouse is still healthy, still living at home and not receiving care, but the other spouse is receiving care, there are certain things, assets in the name of that healthy spouse, what they call the community spouse, which are not available for their spouse's care. A big one is any IRAs or 401ks or those types of qualified retirement accounts in the community spouse's name. They don't have to spend on their loved one's care. You don't have to spend down through that before the spouse receiving care is Medicaid eligible. So what that means is you want to be very careful about when you are privately paying for care, being very cognizant of what you're using to privately pay, to get Medicaid eligible. You don't want to use an exempt asset that you don't otherwise need to pay for a spouse's care, because you're just then making it so that the community spouse has less for themselves when they need care potentially. But you also want to be aware that just because something is in one person's name and not the other does not automatically make it unavailable. It's specifically these types of retirement account 401k IRA assets that are not just like a checking account in one person's name. Those are still considered joint. Even though, that may sound silly, that's just the way the Medicaid qualification rules are written. So it's just goes to show though why it's easy for this confusion to occur if you're not talking to somebody who does this for a living, right? But another thing that you have to be, or that you can be aware of too, is you don't have to spend all the way down to that $2,000 limit when one spouse is still living at home. That's a single person's exemption. So for one spouse receiving care, the other still living at home, after they take the community spouse's IRAs off of it, they can keep the home with no lien on it. That car, one vehicle is still exempt. The life insurance of $1,500 face value is still exempt. But then not just $2,000 in available assets, but between $50,000 and currently about $130,000 of what they would consider available assets are allowed to be kept by that community spouse as well. And how they figure out where you fall in that range is they add up all of the countable assets. So after taking the IRAs, the home, all of that out, what's there, and they divide it in half. They can't force you to keep less than $50,000. So if you only had $50,000 as a married couple, you'd be Medicaid eligible, right? But they also can't, that community spouse then can't keep more than $130,000 of the available assets either for their spouse to be receiving care. So, I've heard bad advice from, what people have found on the internet, or what somebody in trying to be helpful told them at a facility, potentially someone who just doesn't understand Medicaid rules, but maybe was trying to be helpful. You need to spend down to this amount before you receive care, or Medicaid assistance in receiving care. And that's something you want to be very careful about doing without seeking legal advice on that, because that's not true. And you might be putting yourself or your loved one in a worse position by following that advice than they ever needed to be. So the number one thing you can do when you're looking for a loved one needing care soon is sort of a combination of talk to an elder law or estate planning attorney, making sure they have the documents in place that they need, and that they have, you are aware of the planning strategies that they can use, and also making sure that you are working with someone who can help you find the right facility for the loved one, and not just doing, trying to use like reviews on like online or anything like that. I mean, you want to be very sure that the person is receiving care where it's best for them to be receiving that care. So this is a very dense topic, and there's a lot of things you need to be, aware of or get advice on when you're looking for a loved one receiving care. So, if anything created any concerns for you today, or you want to talk more about this, or you do have a loved one who is about to receive care or is going to need some care soon, we have an evaluation form that you'll be receiving at the end of this. If you registered via Zoom, and that gives you a place to say that you would like to set up a time to talk with one of our attorneys. It's a free 2-hour initial consultation. There's no charge for that meeting. So, it's a great place to get your questions or concerns addressed if you have any. Our topic coming up next week, actually, I think next week, is common estate planning myths. So a little lighter of a topic, but it's April Fool's coming up, right? So it's a good, don't be fooled by these estate planning myths kind of fun little webinar. Sort of related to this one, in that there's a lot of bad information out on the internet, or you might be looking at a different state's rules. So always seek the right advice, right? Well, thank you for joining me today, and I hope you guys have a great rest of your week, and I will see you